Wait, please, Your Lordship. Lordship, item number 1 and 2, I'm appearing on behalf of Senior Counsel Mr. K. Agarwal. He's suffering from some eye infection, Lordship. Can it be after the puja?
After?
After the puja vacation, on 4th of November, Lordship.
No. A general prayer has been made on behalf of Mr. K. Agarwal, learned amicus curiae, on the ground that he is having some eye infection.
Lordship.
Ms. B. Bhuyan, additional PP appears for the state and submits that she has got no objection to the same. Accordingly, leave this matter after the vacation.
Lordship, 4th of November.
4th of November. Okay, 4th of November.
All right, Lordship.
May I plead, Your Lordship? I beg to mention item 3 of today's list, Your Lordship.
Yes.
I'm appearing on behalf of Mr. P. Kalita. He's out of station, Your Lordship. Matter may kindly be possible for the day.
Any objection, madam?
Only for the day, Your Lordship.
Okay, right. Miss
F. Hussain,
M. Hussain pays for adjournment on behalf of Mr.
P. Kalita.
What is this, madam? Where is he?
He's out of station, Your Lordship.
Where is he gone?
Golaghat, Your Lordship.
Golaghat.
Yes, sir.
Coming back when? Today?
Not today. Today only he has gone.
You said you wanted adjournment only for a day. So I thought we'll fix it tomorrow.
Not tomorrow, Your Lordship. Next week.
On the prayer for adjournment on behalf of Mr. T. Kalita, learned counsel for the appearance. This is the matter in the mystery.
Oblige, Your Lordship.
Lordship, I beg to mention item number 5.
Yes,
AG is supposed to appear on this matter, but he is engaged in some other urgent matters. Lordship may kindly adjourn and fix the matter after Puja Day. We have already informed the other side.
what to do? We're doing it. Where is he?
Actually, he is in court number 1.
Code number 1. So he's going to be there in code number 1 the whole day. Code number 1 to
Maybe Lordship,
code number 1.
as per his
The chief is arriving only at 11:30. He's going to land only at 11:30. Now it's
some
10:30.
other matters also, as per his instructions, I am informing you.
Code number 1 will start functioning only from around 12 o'clock. Now it's 10:30.
I kindly allow this.
What to do? Who's for the other side?
As what about?
Yes, we have spoken to him.
Yes, Lordship, we talked it.
Okay, Mr. What is your name?
D. Bharadwaj.
D. Bharadwaj, learned counsel, submits that. Now pray for adjournment on behalf of Mr. D. Saikia. Appearing for
Can
the NIA.
Can I?
Appearing for the NIA. He submits that the consent of the respondent numbers 1 to 3, 1 to 4. That is Mr. S. Bhattapur has been taken. Accordingly, leave this matter after the vacation.
Obliged, Lordship.
Item 4, hearing. I've been appointed an amicus curiae
Huh?
for the informant.
Yeah, for the informant.
Yes, ma'am.
So,
The case, my lord, where a 7-year-old boy has been stabbed to death, my lord. Victim is a 7-year-old boy, informant is the father, and there are direct evidences available against the appellant.
PN Gokul was there.
who is he?
PN Gokul, you know. Vivekananda. He's there. Dr. Priyan, he's there, he's coming right now.
Yeah, for the informant.
Yes, ma'am.
Take your seat.
I beg to apologize. Here in this case, your lordship, this of the case is one small boy, your lordship, after being returned from the school.
Yes.
After being returned from the school, your lordship,
Ah,
they came towards one termite tree.
one tamarind tree,
Termite.
tamarind tree.
They have the playground each other.
Huh?
It is right under the roof of the tree.
Huh?
The school boys under the tree collecting some termite tree and some others are playing in the under the tree. Thereafter, this accused person came and without rhyme and reason, kill one person, one boy, 7 years old, and thereafter the case has been
You're for the accused.
accused.
Ah,
So here in this case, your lordship, permit me.
There is any eyewitness?
Yes, there are two eyewitnesses. The boys who were playing in that relevant point of time, the school boys, the other friends have also seen that there is a point. There is an
Eyewitness to the incident.
Yes, my lord, PW3.
PW3 and 4. Lordship, there is a 6 witnesses in this case, your lordship, including IO as well as MO. So, if I start from the page 1, your lordship, if lordship permit me, the incident took place at 2:30 p.m. at 5/39/2019, your lordship.
No, which page are you reading?
Yes, first page, first information report, your lordship. I start from the paper book of this paper book, your lordship, in the page number 1.
Yes.
The general reference, diary reference, entry number 70, and time was 5:30. The incident took place on 2:30 p.m. 5/3/2019 on Tuesday. Accordingly, after being received the information filed by the FIR, it is on page 4, your lordship. The FIR was lodged by his father. His name is Udi Ekka,
Son was how old?
7 years old.
7 years old. This person was mad or what?
It's like that. That has not been mentioned in anywhere, your lordship. But 7 years old boy is there and he killed him.
Just like that. No reason.
The reason is there.
What was the reason?
Reason in the court witness, official in the court witness, before the judicial magistrate, your lordship. Here he has mentioned that the boys, those who are children have taunting him.
Oh, taunting. Okay, making fun of
Taunting
him.
Yeah.
And
Teasing
this,
him.
and this appellant is how old?
At 34 years old.
34. And he's
32
being
at the time
taunted
of
by this
313.
7-year-old boy. And he killed the 7-year-old boy.
At the time of
With a dao.
the
Hit him where? Where was he hit? Where was the boy hit?
the boys are playing inside another roof of the tree. And he also came for a collection of the time.
Ah,
Thereafter, the boys,
started
Teasing
teasing him. Huh.
and out of excitement, he
Not out of excitement, out of anger. Cannot
Out
be
of anger.
Huh.
now the issue remains is that, your lordship, here in this
No,
case,
he hit him where? Hit him where with the dao? On the neck. How many? Two injuries are there? Two
His
blows.
confessional statement is
there
there.
is a confessional statement here, my lordship.
Okay, so what remains? What about the 313?
313, he said that the statement which have been mentioned before the confessional statement before the court is not in that way.
Where is the 313 page?
Page, your lordship, that is in the start from page 22.
Page 22 is 313.
Page 23, he admits that he was carrying a dao, but he did not admit that I did not commit.
So the
crime.
seized that is the dao was seized.
That was seized.
That was seized.
Now, he said on the first question, no, sir, I did not kill him. First question, whether you have killed? The question.
No. The first question, yes, I did not kill.
Then, your lordship, I did not kill him. I straight away point out to the question number 8, Your Lordship.
8. Page,
Page 24,
yes,
if Lordship asked prior to 8, again I asked to question number 7.
yes.
PW6 has also deposed that a learned magistrate record your confession statement. What have you go to say? Police told me that I had killed him. Police assaulted me in the police station. So this is a one part. Police told me to state that I had killed him. Police assaulted me in the police station. Question number 7. Then question number 8. Then question number 8.
Yes.
The most relevant point. The confession statement whereby he is
Okay,
convicted.
yes, yes.
CW1C Binod Prasad, learned SDGM, as Dhubri stated that on 6/3/2019, you were produced before him for recording your confession statement. He explained you the provisions under section 164 CRPC and warned you that you are not bound to make a confession statement. If you do the same will be used against you. Despite such explanation and warning, you wanted to confess, and he sent you to judicial custody, leaving me for reflection till 8/3/2019.
Oh, gave you 2 days reflection time.
2 days and 2 days. Thereafter, Your Lordship, let me go. And you were produced on that 8/3/2019 before him and again explained and warned you as a aforesaid. Thereafter, you voluntarily made your judicial confession. Exhibit Z to Exhibit Z4 and Exhibit Z5 is your time repression. What you have to say? Now, he said, Your Lordship, yes, the magistrate told me that I was not bound to make a statement, that if I were to make a statement, that is confessional element, the same would be used to prove the guilt against me, and that even I do not make any confession statement, I would not be sent back to the police. Yes, I did agree to make a confession statement. So this is the relevant part. Now, the most relevant part is my base of argument on the question number 9.
Yes.
CW1. I stated you confess committing the crime in the following words. The extract parts where
Sir, I stated, CW1 stated.
CW1 stated that you had confessed of committing the crime in the following words. What he said, Your Lordship? Last Tuesday, 5/3/2019, the occurrence took place at noon at about 2:30 p.m. I went to the college, collect tenga, that is soul food, Your Lordship, from a place of our village. At that place, some boys and girls were playing. A few of them were started taunting me. I became angry. I stepped on the neck of a Rajan Ekka with a dao in my hand. He instantly fell down. Later, he died. And you made the said confession statement voluntarily. What have you got to say? I did not make the statement in that way.
Okay, so what, in what way did he make it?
That is the, I don't know what a lordship is.
So that is nothing. It's like saying, it's like somebody asking you, did you sit for an exam? No.
No, lordship.
No, I did not say that I was sitting for my exams. That does not answer the question. So similarly here, there's no answer to the question.
Only,
Anyway, let us go to your PWs.
yes, lordship.
PW2, let us see what is PW.
PW1, your lordship.
1, okay, 1, what does it say?
Married, your lordship.
Yes.
I am informant of the case. I filed the azar in this case. I know the accused present in the court today. The deceased Rajan Ekka was my son. The occurrence took place about 7 months back from today at about 2 p.m. The deceased was 7 years old at the time of occurrence. On the fateful day, the deceased was playing near my home. Deceased was playing near my house on the road with some friend. Then the accused came and inflicted a blow on the neck of a Rajan Ekka by means of a dao. Hence, there was a hue and cry in our village. Local persons rushed to the spot. I was in my peripheral at that time. Local persons informed me about the incident. The accused fled away from the spot, but the local public apprehended him. I saw cut injury on the neck of the Rajan Ekka. He was already died. As informed, police came to the spot. The police conducted inquest on the dead body and sent it for the post-mortem examination. The police took away the accused. The police recovered the offending dao. So that is the examination of the sheep of the father. Then what he said in the cross, your lordship, I do not remember the date of occurrence. The FI was written by other person. I know the contents of the FI. I have 3 children, including the deceased. All my children were playing together on the fateful day. I have not seen the occurrence. My paddy field is a distance about 150 meters from my house. Local persons, namely Urmila, informed me about the incident. There is a tamarind tree at the place of occurrence. There are 3 houses near the spot. Birsa, Letusa, Pagua reside near the house of the occurrence. There was no any quarrel with the accused with me prior to the occurrence. The police came to the spot after 1 hour. It is not the fact that the accused did not hurt to Rajaneka, my baby in Sabitao. So, lordship, there are 3 children in this case of the Rajaneka, of the
What
father.
is there, Mr. Counsel? Nothing in clear cut case. Clear cut.
No, medical documents are there. It is their admitted fact. Only one point I want to argue, your lordship.
Yeah.
That if lordship go to the medical page 11, the cause of death, in my opinion, the cause of death was maybe due to hemorrhage shock with a obstructive asphyxia. Now, obstructive asphyxia in the medical jurisprudence, when it occurs, your lordship, when your breathing is not been fully been supplied by the oxygen in the by through neck, your lordship.
Naturally, your bloodstream, when your bloodstream is cut off, the blood carries your oxygen.
Blood carries oxygen now.
And this is, Mr. Counsel, it's a clear cut case of evidence. There, you have not shaken the evidence of the witness boys. His article is seized. Everything is there. Everything.
Yeah, everything is, if you lordship paperwork, there is nothing left. Only one report, only my part is that he do not come with a predetermination of mind. He come with a to collect the sword of the fruits. And
No.
that will even,
He has given the reason.
no, lordship, what is happened in this case, the moment taunting him in a such a degree, so definitely,
That is his version. Where is your cross-examination of the young boys that they were taunting him?
no, because all the, out of 3 children, so 2 children are from the informant.
But you had the right to cross-examine. No one was telling you not to cross-examine. Then where is your evidence that you are being taunted?
Lordship, in such circumstances, the conviction have been done. That's why he make a repetition that I want to confess myself. What is the reason if I am not being confessed?
In his confession, did he say that he was being taunted?
Yes, it's been there.
Where?
If you go to the page 78,
Page 78 is the confession.
yes, confession. What he said. This is the version of the collection, the version of the for the judicial magistrate. The incident took place last Tuesday of 5/3/2019. At 2:30 p.m., I went to certain place of village to pluck tenga, whose sore in taste. Some children were playing there. Some of them were teasing me. I got angry with the dog, then that is in my hand. I hacked the neck of a dog. Boy named Rajanika. He fell down instantly.
So who teased him? Did the deceased tease him? Is there any evidence that the deceased was teasing him?
Lordship, the confession statement and thereafter the judicial magistrate had reflected him for twice, 2 days, your lordship. And he repented
No,
that I have not committed.
no, Mr. Counsel. What? Not committed what?
That he has, in the judicial magistrate judgment passed by the trial court, your lordship, it has been mentioned. If lordship permit me, I will show you.
No, when the witnesses have seen it, what else do you want?
Lordship, all the witnesses where they have seen are the
You
some of
see, and the question of grave and sudden provocation would not be attracted here. For the simple reason, whether teasing would amount to, would you see the response by the thou, is it proportionate to the provocation?
Lordship. This is a case
I
where
think Supreme Court judgment is not in your favor in this.
no, Lordship. This is the case where Supreme Court says that it is a case.
Oh, very good.
Lordship has a different perspective in your mind because it is a different matter.
No, no.
But my point, what submission by the Supreme Court says that when there is a case of sudden provocation, the word provocation, angry, it will come under 304 part 1.
Just show me the evidence where it says that this deceased had provoked the appellant. Where does it show? There are around 3-4 boys, correct? There are around 3-4 boys. Now he has killed this deceased. Where is that evidence that this boy had provoked him? Or supposing, say in this room, say there are 20 lawyers here. All of you provoke me. Or some of you provoke me. Do I kill anyone that I feel is amongst them? And then can I say that some out of the 20 had provoked me, so I killed one. I do not know if he provoked me. Will that be justified?
Lordship, here in this case, what is happened? All other relatives, the school boys, Lordship, please, Lordship, out of this informant, they have 3 children. Out of 1 children have been died. 2 children are there, still there in the plane. It is there, Lordship. If you see,
So one children died, so
Now-
they've got 2 children left, so at least they've got 2 left. That's what you're saying.
no, my Lordship is that the issue remains of the provocation. That part is totally not.
As the
been-
council, it has to be proportionate. The reaction has to be proportionate. It is not like somebody comes with you with a small 2-inch stick, 2-inch piece of wood to hit you, and you go with a bazooka and blow his head off. It has to be proportionate. This is a 7-year-old boy. Supposing he was teasing you, you chop off his head with a dao. Is it proportionate?
But that situation, situation is.
That is what the exception 1 to 300 has been read down by the Supreme Court. It has given the various conditions under exception 1, which has to be fulfilled, so that you can take the aid of exception 1 to make the case fall under 304 part 2 or part 1, wherever.
But
Where is this 7-year-old boy? He's plucking tamarind. There is nothing in the evidence to show that this deceased boy was teasing you. Maybe one of the 3 of them were teasing you, but not the deceased boy. But you go take out your big dao and go on, finish. Is it? Where is the proportionate response? Say in a service matter. In a service matter, someone is guilty of misconduct, say charged with misconduct, and say he's found guilty. One of the defense that is always taken is the penalty should be proportionate to the
Conduct of
misconduct.
others,
Yes,
misconduct of
yeah, to the charge. Now in this case, one 7-year-old boy is with his friends. They are picking tamarind from a tree. None of them have got dao, none of them have got a pistol, none of them have got a danda, nothing. And one of them was teasing you, but you pick out the first boy and just finish, his life is gone. Is it justified? Think of it, is it proportionate? When someone teases you, do you go and chop off his head? Then no one will be safe in this world if that is acceptable. Supposing you are walking in, say, in some bazaar somewhere here, Uzan Bazaar, and then
I'm staying here, sir. Lordship.
you Uzan Bazaar and you go haggling for fish. The price, you say 250, he says, no, 350. And then you say, no, he is taunting me, hack finish. Is it justified?
This justify your Lordship. The first point, Lordship has
7
pointed out
year
the
old boy, no.
mental illness, your Lordship.
So
That
where-
has not been discovered in this paperwork.
So who stopped you from taking up that plea?
That is not been discovered here in the paperwork with my limited.
No. And have you taken up that plea ever? Even in the appeal? That is
But-
not your plea.
Rightly, wrongly, Lordship, the amicus curiae of this case in the trial court smash away all the points. The issue remains is the vital issue. In the even the court, trial court also observed her conduct of the case. I have nothing to develop. But my point is that, Your Lordship, whether
No, you had you could develop it, you could take up the plea that you could have filed an application saying that he's having a mental problem. I want a psychiatrist examination. That no plea is taken. And it's too late now in the day to take it up.
But the only point is that, Your Lordship, my impulsive drives have a set of mind to point before this honorable
Yes,
court.
yes.
He repeatedly asked to voluntary confessing statement before the court.
Huh.
The court is checking repeatedly that no, if you go, that consequence will be that one, warning him.
Correct. That's the court should do that.
Now, the issue remains is that he repent.
He repents.
Yes,
But that doesn't bring a dead boy to life.
he repent. Now, my
He
point,
repents. That means he admitted.
now it is in the court's judgment says in the trial court. My humble submission before this honorable court that where there is a 302 case,
Yes.
where there is a motive,
But there's a motive. Okay.
that is missing here.
No, Mr. Counsel. Motive will come into play when there is no eyewitness. When there is an eyewitness to the crime, there is no requirement of motive. You see, when in a case where the circumstantial evidence is the way to find out whether a person has committed a crime or not, the question is, why would this person kill him? But here, question of motive is not relevant for the simple reason that it has seen that he has been killed. The motive, he might have anything. We do not know. If he doesn't want to tell us, we do not know. So in cases where there is no eyewitness, then only motive becomes very important. Not in a case where there is an eyewitness to the crime.
Out of-
Sorry. That you are appreciating the law the wrong way.
Lordship, out of 7, I have killed 1.
Thank God, only one.
Suppose, sir, take an assumption, sir, I have killed 1. Then if I choose to kill in front of me, thak, I can done it. I have done only 1.
So what do you want to say?
That is why I'm trying to say that this is not a case. This is not a case to establish under 302. My limited knowledge here, Lordship. What
Your-
I have
Your limited knowledge is that you have hit one 7-year-old boy with a dao. Did you have any idea that when you hit him with a dao that he would be killed? Or that no, he'll put band-aid over and he'll still carry on picking tamarind. What would a normal person think when a 34-year-old hits a young 7-year-old boy with a dao on the neck? What do you think will be the result? A normal person would think that band-aid will not solve the problem. Probably coffin will. Yeah, I think there's more than enough. Yes, anything, madam?
People of life.
If your lordship takes into account the evidence of eyewitnesses, only PW3 can be relied upon because PW4 she has stated in her cross-examination, she was on the top of that.
But then she saw.
She saw, but could not. Lordship may kindly have a look.
Okay, doesn't matter. One is enough.
One
You don't have to count
One
the
is enough,
witnesses.
my lord.
Uh.
She said it is not easy to watch what was happened under the tree. And there's a line, I could not see the face of the person who was assaulting the victim. So the evidence of one person. it's
More
not
than enough.
More than enough. Coupled with the 164 statement. Lordship, but one factor is correct in submitting that he was not, as usual, he was carrying a dao in order to cut the Tenga, my lord.
Probably, or
Yes.
maybe some bamboo or
Lordship.
firewood
But
or
the
anything.
gravity of this one injury, my lord, it was too harsh, my, in the sense.
Correct,
was
it has
on
to be proportionate. And then there are
It
two
should be
injuries,
proportionate.
one on the neck, one on the shoulder.
Yes, my
And that is on a vital part of the
lord.
body. So where does the exceptions to 300 come in? They don't come in at all.
I'll be relying on one judgment, 2000, on single eyewitness, 2006, 11 SCC, 323,
2006, 11 SCC,
323,
323.
my lord.
Para?
Para, my lord. Lordship, para 10, I'll be, here, evidence of single eyewitness. In the instant case, we are left with the evidence of a sole eyewitness, and it is therefore becomes a duty of the court to critically scrutinize her evidence with a view to assure itself that the witness is Starling,
Para 10?
para 10,
No.
Matra para 10. However, in the instant case, my lord, the line starts.
No, how does the paragraph start?
However, the instant case,
Para 14.
here I para 10, my lord. However, in the
That
instant
is the
case.
problem with Manupatra
Yes,
and
my lord.
SCC.
Yes, my. So it was Starling quality, lordship.
Lordship,
So he says that it will come under 304.
I agree with,
He says that exceptions will apply. How does it apply according to you?
Too harsh. That's why I want to say,
What is too high?
in a sense, it was on the vital part of the body. And but there, if your lordship considers the 164 state manuscript is corroborative in nature, my lord. So lordship, there was a bit of provocation because these boys were teasing. But it did not come, it did not come from the evidence that this particular boy, the victim,
Even
he was
if
teasing,
they were teasing,
my lord.
even if 7-year-old boy is teasing, why should the retaliation be of such a nature?
It depends upon one's mental.
It is like one boy is coming with a catapult and the other side is coming with a tank.
It's true, your lordship.
Arre,
Depends
where
upon the
is the
mindset of the
proportion?
person, my
Yes,
my thoughts are there in this Supreme Court judgment, your lordship.
your thoughts.
Whatever I have argued,
He's
argued,
a
your lordship,
doctorate, my lord, so.
lordship,
Things
he is also different. I maybe point out and lordship will be go in different direction. Lordship, I just point out my
No,
concern.
you should. We'll consider.
That may be appreciated as I make a screen of before this honorable.
Yes. Which para?
Paragraph number 8,
Para
8, 9, your lordship. Whole paragraph mentioned in the paragraph 8, your lordship. That due to paragraph 8. Lordship got it?
Yes.
Yeah, my staple
No, you have stapled it wrong.
wrongly. Coming with a wrong quote, your lordship, wrong case. So sometimes.
We are nearly quoting the wrong case. 397, 39. 397, 7, 396, 395, like this.
397, your lordship.
You have done it the wrong way. We would be quoting the wrong judgment.
It is just a matter. Supplement is there, lordship.
Para 8.
Yes, lord. Only on paragraph 8. Why did you do paragraph 8?
No, it's okay. I've got. The fourth exception covers a sudden fight.
Yes,
Where is the sudden fight?
Lordship.
there was no fight. It was-
And then he's saying, how will the exception 4 come into play? Exception 4 is in a sudden fight. Your case is of teasing. There's no fight.
Exception 1 would have come.
That is what he's trying to
Yes.
say, exception 1, where there's
Lordship.
loss of self-control, when there is grave and sudden
the
provocation.
And it says causes the date of the person who gave the provocation or causes the date of any other person by mistake or accident. There's no evidence.
Lordship, please page 395, paragraph 9 in the head note. Lordship.
Page 395, head note. Okay.
Yeah, the head note.
Yes.
D number.
D number, yes.
Penal Code 1860 under
Yes,
section
yes,
302 or 304 part 1.
Yes.
Applicability of section 300 exception 4 IPC.
Yes,
Once you, that means brother of the applicant as freezing the data of the deceased uncle.
yes.
This is along with the uncle and PW5 going to the house of deceased uncle, house of the S to ascertain the reason thereof. On not finding you, this is going there again on the next day, insisting S and U to come for settlement. Refusal of S and U to do so, giving rise to quarrel. At this moment, S going inside the house, bringing a knife and inflicting blows with it on the back of the deceased. When deceased turning his face, S piercing his knife into his chest. Hail section 300, exception 4 applicable. Case not covered under section 302. Conviction of S altered to 304 part 1. Custodial sentence of 10 years hail would be proper.
Mr. Counsel, I'll just tell you, it's very dangerous
To read
to
the.
rely on the head notes without reading the section. Now, let me read the section for your knowledge. Explanation 4, exception 4.
Lords.
Culpable homicide is not murder if it is committed without premeditation in a sudden fight. There has to be a fight. In the heat of passion, upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner. So where is the sudden fight between you and the 7-year-old boy?
But heat of passion is there when it will cool down.
Mr. Counsel, when there is a heat of passion, there is no cooling down. Heat of passion means it's rising. Your passion is rising.
Who have indicated me, your lordship, in my mind? These are the boys.
The first thing is there has to be a fight.
That is I admit that proportionate of
Okay,
the
right,
age
right.
defined with
Your Lordship, my young friend may also be heard. He'll
Yes,
give his
yes, yes.
comment.
Naturally, naturally. Yes,
Lord, I would also like to place reliance on two judgments, my lord.
yes.
One of the Honorable Apex Court and one of our Honorable Guwahati High Court.
Yes.
My lord, with regard to motive, my lord, there are catenary of judgments, my lord. It says that motive is not important and there are.
Motive when the eyewitness is not required.
Yes, including this one, my lord, that I have just brought, my lord, that is 2024 INSC 276 from Justice Dolia, my lord. So this is judgment, which is para 6, my lord.
Para?
Para 6.
Give me. Where's the copies?
Para 5, my lord. Page 6, para.
Right. Oh, you have only one copy.
My lord.
We are two of us. What to do?
You can check paragraph 5, my lord.
What to do? What to do?
I'll give another copy. 2 additional copies.
You see, you have got to extend the basic courtesy to the court. There are two of us.
Yes,
We are both listening to your case. It's not that only I will sign the order,
my lord.
or she will sign the order. Both of us have to sign the order. Please extend the basic courtesy to us. Okay, you are a lawyer.
Right.
You have to, these are basics. The Justice Julia judgment read para 5 and 6.
Para 5, my lord.
Para 5.
Page 6, para 5.
It's clear, there's no requirement of motive when there's eyewitness. So that's there. That's all.
No, there's one more, my lord.
Again, one more and one more judgment.
2, my lord.
Two? Oh, very good. You have given your copy.
No, my lord, I have mine.
Okay, they are improving within a span of 2 minutes. Very good.
Under para
Para?
6 and 7, my lord.
That's it.
My lord, para 6 after a few lines, my lord.
Yes,
to
yes.
reading. She also deposed that at the time.
Which line? 6 line?
After 12 lines. She also deposed that at the time of the incident.
She also deposed.
Yes, my lord. She also deposed.
Para 6.
Para 6, my lord.
It's not 12 line, Mr. Counsel.
My lord, she also deposed, my lord. There's
17th line.
my lord.
Please be very specific. You have got to learn these small things. You see, you lose the attention of the judge otherwise. Please be specific. You take a little bit extra time, but when you say something, It should be dot to the point. In fact, you see, in some high courts, on facts, they were very clear. Maybe in the law, it'll take some time, but on facts, they knew where it was. So you've got to have that habit. Yes, he also deposed.
That at the time of the incident, her brother Atibur was with her. PW4 also deposed with great consistency in tune with his sister, that is PW3. He deposed that he saw with his own eyes the appellant stabbing his mother. The narration of the events by both PW3 and PW4 remains unshaken. Their testimonies corroborated each other. PW2 had deposed to the extent that on the date of occurrence, while he was proceeding towards his house, his appellant brother attacked him with a sharp weapon and stabbed him on the right side of his stomach. He started shouting, and on reaching the gate of one Samiruddin, he fell down on the earth and thereafter lost consciousness. When he regained his sense, he found himself at Silchar Medical College Hospital. Although the weapon of offense, then para 7, although the weapon of offense could not be recovered, the eyewitness accounts of PW3 and 4 together with the medical evidence on record establishes the same as a sharp cutting weapon capable of causing death when used as an instrument of offense. So, my lord, credibility of two direct eyewitnesses along with medical evidences, my lord. In our case, my lord, the Dao is the weapon. And
It was
medical
seized
evidence
also.
makes it absolutely clear. So, my lord,
And I think he was arrested on the same day, correct? On the date of the incident. Appellant, he was caught by the others, caught by
Yes,
the
yes.
villagers.
and then he was
Where,
given to the police.
that's all.
My well, there's also evidence of PW5, my lord. He saw the appellant washing the murder weapon.
Yeah. Anyway, one is enough. Heard Dr. B.N. Gogoi, learned counsel for the learned amicus curiae or what? Learned amicus curiae. Full stop. Also heard Miss B. Buyan, additional PP, and Mr.
S.H. Mahmood.
S.H. Mahmood for the respondent. Number two.
Informant, buddy. Informant.
I know, but respondent number 2.
Yes.
Respondent number 2/informant. Right.
Lordship, the lordship, maybe the lordship.
Okay. Okay. Then who will take up the next case? Okay, you all are there. You all are there. Okay. Correct. The appellant has put to challenge the impugned judgment dated 24/2/2021 passed by the Sessions Judge Baksa Mushalpur in Sessions Case number 114/2019, by which he has been convicted under Section 302 IPC and sentenced to undergo imprisonment for life with a fine of rupees 10,000, in default, rigorous imprisonment for 1 year. Wide sentence order dated 25/2/2021. Musa. Okay, should we dictate or should I dictate or should I give it faster? No, should I save it? Huh? Okay, hearing concluded, judgment reserved. So basically, outcome to but then it'll take some time just finalizing. Okay, next.
And deeply obliged.
That is a case where the petitioner.
Difficult.
Yes, we know.
Yes. Any eyewitness?
Eyewitness is not there. Circumstantial evidence, your lordship.
Judicial confession is there, Lordship.
Uh,
Extrajudicial.
It is so far, but so far, the contradiction in the evidence of PWs that is there.
Okay, let us see the FIR.
Page number
FAR,
4,
your
Lordship.
lordship will find 4. Married with my humble submission is that at around 10 p.m. on 2/4/2019, accused Sri Pavitra Paswan assaulted his elder brother Raju Paswan on head with piece of wood while he was sleeping and thereby killed him. There is no other person in their family except them, the 2 brothers, and none of them are married. I therefore pray to you to take necessary action after investigation into the matter. Now, lies your lordship.
Who is this informant?
Informant he's a villager actually.
Co-villager,
Co-villager.
Co-villager.
But same title,
Lordship,
Yes, my lord.
Paso one.
Lordship.
And that too, that affair has been lodged after getting information from a lady. He was informed by a lady.
Anyway, this occurred at night, 10 p.m.
Yes, my.
In the villages, so they sleep very early.
Yes. He was about to sleep at that time. It was 9 p.m.
9 p.m. is very,
Yes, in village area.
it'll be all quiet.
Yes.
Then what happened?
Then my lord.
So 302 charge framed under 302.
Yes, my lord. After under.
Pleaded not guilty.
Yes. He pleaded no guilty.
Then let us see the evidence.
Lordship may turn to page 10.
Yes,
Of this, it start from
page 10.
page 10. It's
CW2.
PW2, he is the informant.
Yes.
I am the informant, and I know accused Pavitra Paswan, alias Paltu, who belong to our same village. The incident occurred hardly 1 year back at about 9 p.m. At the time, I after the dinner just go for sleep. While I was so sleeping, an old lady of our neighborhood, I forgot her name, came to our residence and told me that accused Pavitra Paswan killed his own brother by assaulting him with a piece of wood on his head, and she came to know about the same. Having heard about the incident, I got up from my sleep and I directly visited the house of VGT leader Harakanto Robidas and informed him about the incident. Accordingly, all the villagers rushed to the spot and noticed that the dead body of Raju Paswan was lying on the ground. The wooden piece by which accused hit the deceased was also lying nearby the dead body with blood stain, my lord. In the morning, when I noticed the injury closely, I saw the brain materials coming out from his injury. When people gathered at the spot, accused fled away and silently taking shelter in the school premises. But the villagers searched, caught, and brought him to the spot, and we kept him confined and passed of the night there. Then matter was informed to police by VDP member. When police visited the spot, I went to Koirapari PS and lodged the formal FIR, that is Exhibit 2. Is the said FIR, Exhibit 2(1) is my signature. On the spot, police seized the wooden pitch and I stood as witness to the said seizure. Exhibit 3 is the said seizure list. Exhibit 3(1) is my signature. Exhibit A is the wooden piece seized by police, and I have seen the same in the court today. During investigation, police recorded my statement. And cross, my lord. My residence is not situated far away from the residence of accused, since at the time of incident, I was sleeping in my residence, so I cannot say exactly the cause of incident or having any enmity between the brothers or not. I have seen abnormality of the accused for last 3-4 years, and he did not receive any treatment, my lord. That abnormality part is there. He did not receive any treatment of his mental problem due to lack of money or lack of guardian. The deceased was a habitual drunkard and he hardly worked for his livelihood. Most of the time he was under influence of alcohol. Because of his mental disturbance, accused hardly stay in his residence. My lord.
He used to move here and there. Only deceased used to stay in his house, which was in a dilapidated condition. There is residence of Moti Das nearby the house of deceased. I put my signature in the seizure list in police station. It is not a fact that accused was not involved in the crime. This is PW2, my lord. PW3. I know the PW3, 55 years. Moti Das, Your Lordship. I know the informant Hitesh Paswan as well as accused. Both are my neighbors and also know the deceased who is the brother of the accused. The incident occurred hardly about 1 year back at 9 to 9:30 p.m. The deceased was a habitual drunkard. On the day of occurrence, I was sleeping under the influence of alcohol. Accused has been suffering from mental disturbance and he lost his parents. So he moves here and there. My house and the house of accused is adjacent. In my house, my whole mother, Bokuli Das, is also there. On the day of occurrence, my mother heard a sound nearby our house. Then coming out from the house, my mother noticed that the accused is moving around nearby his house. Then my mother saw in the flash of torchlight that dead body of Raju Paswan was lying on the ground with a pool of blood. Then I came to the spot and called other villages. My mother also called informant Hitesh Paswan. DDP was also informed. In the meantime, accused took shelter inside the school building. Then we, all the villagers, stressed him out from the inside the school and kept the accused confined in the house for the whole night. Later on, the matter was informed to the police, took the dead body to the police station, did post-mortem. During investigation, police recorded my statement. The cross-examination, my lord. At the time of occurrence, I was in my residence, so what had actually happened, I did not see. All the villagers know that accused is mentally ill, my lord, but he did not receive any medical treatment due to want of guardian. Accused mostly stayed in bosses nearby the river bank alone because of his mental disturbance. Maybe accused committed the crime because of his mental disturbance and lack of understanding about the act done by him. And PW for my lord. Horokanto Robidas, my lord. I know the informant Hitesh Paswan and the accused Pavitra Paswan Paltu. This is Raju Paswan, also known to me. About 2 years ago, on one day at about 9 p.m., Nepal Paswan came to my residence and informed me that accused had killed his elder brother Raju Paswan by beating with a stick. Then I went to the spot and saw the dead body of Raju Paswan lying on earth at his residence. I also searched for accused. Accused was found sitting in the veranda of the school. Then I, along with other person, caught the accused and brought him to the spot and confined him by tying with a rope. Then I informed the police immediately. At the time of investigation, police seized the lathi, which was used by accused for causing murder in my presence by preparing the seizure list. That is Exhibit 3 is the seizure list and Exhibit 3.2 is my signature. Accused himself confessed he is guilty before me and he disclosed that he had caused murder to his elder brother. Police recorded my statement. Cross-examination, my residence is away from the place of occurrence by 500 meters. At the time of causing murder, I did not witness. Accused and his elder brother were residing under a tin set house with his dilapidated conditions. This was a habitually drunk. Sometimes the accused suffers mental problem, my lord. Besides the place of occurrence, there are the residents of one Pulu Das and Modhus Sohan. Police arrived at the spot in the morning.
Okay, so basically, is that whether the accused was suffering from any illness at that particular time?
Yes, my lord, that question.
You see, otherwise it appears that he has committed the crime. Correct?
Yes, my lord.
He has given extrajudicial confession also.
That is before.
Now, what is the procedure to be followed in a case where a person may or may not be in control of his senses due to mental illness at
Yes,
that
right.
relevant point of time? What is the law?
Or see regarding that.
Yes,
There
It is
no
to be taken
explanation.
care by the.
Only he have said that I am not mentally disturbed, but no treatment, no such treatment or.
no, but then isn't there a duty on the part
Yes,
of the
yes.
court to do something?
Yes, my lord.
That
That
is also not done, that
the
is
Supreme-
defense.
No, but what is the duty? What is the duty of the court? When there is a witness saying that he is mentally ill,
yes, all the
or
witnesses.
sometimes he is ill, is there any duty cast upon the court to find out whether that person can stand trial or not? Tell me the law.
Yes, the court has to be careful so that justice is not miscarried.
Show me the law, Mr. Counselor.
Yes, my lord, I have good adjustment there.
Defense must
Can I-
have taken that plea, lordship.
Huh?
Defense can take that plea
No,
at that
no,
time
no,
of trial. that he may
madam, please understand.
It rests
A
on
person
prosecution
of one
also.
sound mind,
be Unsound mind.
he does not know that he is of one sound mind. Okay? So a normal person should be able to find out from the evidence already recorded that that person has been said to be of unsound mind. And as such, won't the duty be cast on the court to find out for itself as to whether that person has the capability of standing trial and defending himself?
Lord, please file.
Tell me the law. I don't want to know your opinion.
Lordship.
I want to know the law.
It is Rupesh Manga,
Page?
page lordship, 5.
Yes,
From the below, this one, the last paragraph.
yes.
The doctrine of burden of proof in the context of the plea of insanity may be stated in the following propositions. The prosecution must prove beyond reasonable doubt that the accused had committed the offense with the requisite mens rea, and the burden of proving that always always rests on the prosecution from the beginning to the end of the trial. There is a rebutable presumption that the accused was not insane when he committed the crime.
Rebuttable.
Rebuttable. In the in the sense laid down by Section 84 Indian Penal Code, the accused may rebut it by placing before the court all the relevant evidence oral, documentary, or circumstantial, but the burden of proof upon him is no higher than the rest upon a party to civil proceeding. Even if the accused was not able to establish conclusively that he was insane at the time he committed the offense, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the court as regards one or more of the ingredients of the offense, including mens rea of the accused, and in that case, the court would be entitled to acquit the accused on the ground that the general burden of proof posting on the prosecution was not discharged.
Regarding when accused making the career plans of mental insanity. It's a number code on earlier occasion, open Bosumakari methods. Elaborately discussed.
You see, because here, the appellant has been accused of murdering his brother.
Brother.
Now, all the witnesses say that he suffers from mental illness. And they say that the entire village knows it. Of course, some witnesses are saying that sometimes he suffers.
Sometimes.
Now, you see, usually what happens is when there is some defense or alibi made to that effect, unless the person who says that he is mentally unsound is able to prove that he is mentally unsound, then that should not be accepted. The fact here is that the witnesses themselves, the prosecution witnesses, all of them have said that he is of unsound mind.
Yes.
Now, so can you accept part of the evidence and not part of it? Yeah, you either accept it in full or you don't accept it at all. So if you're going to rely on some part of the prosecution witnesses' evidence to prove the guilt of the appellant, what will happen to the remaining part which is not in your favor? Can you say that no, the court should ignore this, can ignore this, can it be done? Because section 84 is the section I think you are relying upon. Section 84 IPC.
Yes, 80.
So now what to do? Shouldn't there be a now? But the problem is, how do we know that at that relevant time he was insane? That is the problem.
Yes.
Actually,
After his arrest, he was medically examined,
ah,
but so far that report is the,
there is any medical report.
no, I have not found so far in respect of the accused actually. The prosecution side may, because after apprehension, he must have been,
Give me that judgment, the Basumati judgment. 40 pages. It's okay. But yeah, both sides.
and so far that seized weapon, that article that was not sent to the FSL also.
What?
That
The
yes,
the
yes,
weapon.
yes,
The weapon.
the weapon. That
But
was not sent to the FSL.
but then it has been seized.
That has been seized.
Was there any blood stain on it?
That was blood stain. That is blood stain, but that was not sent to the FSL.
In 313 only the accused denied lordship, but he couldn't explain the reason why he.
No, yes. No, you see, you cannot expect an insane person to explain himself. It's can you expect a beggar to give you money? I don't think so. It'll be the other way around. The beggar will expect you to give money to him. Similarly here, I don't think an insane person can explain himself when he's insane. Can you say that the mad person will prove yourself to be mad? Can you do that? So the thing is that actually what is the thing that has to be seen is, was there any attempt made by the court or by any person to show that he was not in his senses at the relevant point of time when the incident occurred?
The problem is that there's no doctor to do it. Okay, so that is done. No, and the source of the most source should have sent him for medical test to find out whether he is.
Yes.
He's in jail.
My lord, section 328 of CRPC also provides, when a magistrate holding an inquiry has reason to believe that the person against whom the inquiry is being held is of unsound mind and consequently incapable of making his defense, the magistrate shall inquire into the fact of such unsoundness of mind and shall cause such person to be examined by the civil surgeon of the district of such, whether that has been adhered to or not during the.
So please look, that's what I'm asking you.
Yes, my lord. 328 is there.
Then,
That section provides.
so now, what do we do? Do we send this person to be examined?
That is better lordship. Let the person.
But
be
then
examined.
can it relate back to that period where he had committed the crime in 2019? He'll have to have some kind of magic ball or something to see into the past.
That can, but at least it will be clear.
We have to see whether he's really mad or not.
Madam,
Hmm.
that will.
Then he's not in his senses, mentally imbalanced.
After he was sent to jail, he was treated or not, or he was
No, I don't think he'll be treated.
in jail.
He's in jail right now, or he's on
in
bail.
He's in jail. He's in jail.
He's
If
jail
he is
appeal.
mentally disturbed, then lordship.
Then he shouldn't be in jail. He should be in the mental asylum, maybe in Tezpur.
Whether because that aspect that has been rejected by the trial court, no? The
That
trial
is what
case-
I'm asking you. Please
Yeah,
look.
that has not taken into consideration, my lord.
So please look. Here two counsels are there who can look. Don't expect the two old judges here to do everything. Whether this aspect was looked into. Because even if we cannot come to a finding with regard to whether the accused was in his senses at that relevant point of time, the
Yes,
second
yes.
issue is whether if he is not in his senses now, mentally unstable now, can he be allowed to remain in the jail? I think he'll have to go
And my
and he might need treatment.
My lord, the judgment which I have given at para 20, the first paragraph also,
Para 20.
Yes.
Yes.
it is a circumstantial proof to prove the lunacy or insanity is on one reasonable doubt. For this, we may profitably refer to a judgment of this court, Dayabhai,
Yes.
yes, it is a fundamental principle of criminal jurisprudence that an accused is presumed to be innocent, and therefore the burden lies on the prosecution to prove the guilt of the accused beyond reasonable doubt. The prosecution, therefore, in case of homicidal, shall prove beyond reasonable doubt that the accused caused that with the requisite intention described in section 299 of the Indian Penal Code. This general burden never shifts, and it always rests on the prosecution. But as section 84 of Indian Penal Code provides, then nothing is an offense if the accused at the time of doing that act by reason of unsoundness of mind was incapable of knowing the nature of his act or what he was doing was either wrong or contrary to law. This being an exception under section 1005 of the Evidence Act, the burden of proving the existence of circumstance bringing the case within the said exception lies on the accused, and the court still presumed the absence of such a under section 105 of the Evidence Act. Read with the definition shall presume in section 4 thereof. The court shall regard the absence of such circumstances as proved unless after considering the matter before it believes that said circumstances existed or their existence was so probable that a prudent man ought under the circumstances of the particular case to act upon the supposition that they did exist. To put it in other words, the accused will have to rebut the presumption that such circumstances did not exist by placing material before the court sufficient to make it consider the existence of the said circumstances so probable that a prudent man would act upon them. The accused has to satisfy the standard of a prudent man if the material placed before the court such as oral and documentary evidence, presumption, admission, or even the prosecution evidence satisfy the test of prudent man, the accused will have discharged his burden. The evidence of place may not be sufficient to discharge the burden under section 105 of the Evidence Act, but it may raise a reasonable doubt in the mind of a judge as regards one or other of the necessary ingredients of the offense itself. It may, for instance, raise a reasonable doubt in the mind of the judge whether the accused had the requisite intention laid down in section 299 of the IPC. If the judge has such reasonable doubt, he has to acquit the accused, for in that event, the prosecution will have failed to prove conclusively the guilt of the accused. There is no conflict between the general burden, which is always on the prosecution, and which never shifts, and the special burden that rests on the accused to make out of his defense of insanity. So general burden also rests on the prosecution, my lord, and the judge, as per provision.
But then special burden rests on you.
Yes, my lord. But so far, that section 320 of CRPC that provides, if from the if in the during prosecution evidence, if the judge comes to know that the question of insanity, so he can go for an inquiry into that. That provision is there,
Lordship, after he was
but that
arrested,
has not been adhered to so far. This case is concerned.
after he was arrested, Lordship, he was sent for medical examination. At that period of time, no such allegation was there. No such report was there. According to it, Lordship, only no injury, no any part of the body injured, nothing in the report, Lordship. It is in the LCA, Lordship. That after next day, the medical, I request to kindly examine the following accused person just after the arrest. Lordship.
Yes, what are you saying?
Lordship.
All the PWs, they told that he is a person of unsound mind.
And
that time.
the problem is that
And he lives in the bushes also, in the jungle. Sometimes he comes to the house, my lord.
what is it?
He's like a mad person, my lord. That PW,
Medical health officer.
PW,
You know, this is just for, it is not
Still
as per
Lordship.
328. it is
yes,
as
yes,
per
my
that.
lord.
This is when he was being sent to jail.
Gen,
That is,
That's a different thing. That's different.
as per this provision, my lord,
That,
that
those
can-
are to see whether he's healthy and all that sort. They don't really go into
But if
his
it's
mental
unsound
condition.
mind, Lordship, then doctor would at
yes,
least
my lord.
suggest that he
Yeah.
is not of mental.
No, for
Or
that you
that
need,
type.
no, madam. When there are 50, 100 people being taken to the hospital, the only thing the doctor does is checks whether they are healthy or not. He doesn't have time to ask them questions. Yes, what do? You have got parents. There's no time for that. Nothing like that. It's
Yeah,
just
but
perfunctory. They just see.
his
check,
behavior
check.
will reflect, Lordship.
No,
Unsound mind.
no,
behavior will-
not. Sometimes no. May not.
No.
It's not like that, madam. Yes.
He was
Let us not try to take the role of a doctor.
yes, my lord.
Okay, you see, there are many cases where only once they start speaking that you'll realize that there's something off. Some people may be smarter than you and I, look wise, but when they start speaking, then you know that they're from planet Mars or something like that.
He was required to be examined by a civil surgeon or medical officer.
Not done. What to do now?
And my lord, so far that seized weapon is concerned.
Yes. Now what to do at this stage?
PW8 Lordship, where he have done his extrajudicial confession, Lordship.
And
In PW, with PW8, when I asked the accused confessed his guilt. And he admitted before me that he had killed his elder brother. He also further stated that as he was earlier assaulted by Raju, the deceased, as he was earlier assaulted, because both were in a drunken state, Lordship. So he killed his brother. I noticed the injury on the forehead of the deceased. I also found one piece of wood with blood stain, which was taken in his hand. Lord.
Madam, that,
Two,
see,
three.
this is a village.
The only
Let
thing is
us-
that while he was have done the activities, he was in proper.
It's a village. Have you gone to a village? I don't know. I've been to many villages, small houses, 50 houses, 100 houses at the most. Everyone knows each other. And your neighbor knows more about you than you know than about yourself usually
Lordship.
in
It
these
is the
villages.
fact, Lordship.
So when they say that the entire village knows that he's an insane person, I'm telling you, in uh, all probability, he is an insane person. Now, only problem is now much water has gone down the bridge. And now what to do at this stage? That is the problem. What to do, madam, at this stage?
For end of justice, can the jail authorities be directed to examine him as to his mental status, whether his condition is stable, whether he behaves abnormally?
Like the jail authorities or the
He is in
transport?
jail, his behavior in jail, so a report will be given by the jail doctor.
No, jail doctor will not.
Mental.
As per 328, I think surgeon has to be. Yes.
surgeon or medical officer.
Mental health board will be there.
Medical board.
Medical.
Board will be.
Because correct. Now only thing is that now people are mentally unstable. They cannot be here. So what to do, madam? You see, one thing is that I don't know at this stage, we just discussing and we're saying that what occurred during that time. Now, no one really knows what was his mental state. There's no doc, there's nothing. He has to prove his mental condition. Now, for a poor villager, that's out of the question. Besides being ignorant. Now, the only thing that will matter is whether, supposing we come to a finding that yes, he's the one who has committed the crime. Then whether it would be proper to let a person who is of unsound mind now to remain in jail or to go to a proper facility.
Lordship, I have not seen the evidences of the prosecution cases. The Lordship, after perusal of records, it found the evidence from prosecution cases that he is suffering from unsoundness of mind. So Lordship, and they.
We're not from the document, from the evidence of the
Evidence.
witnesses. Prosecution, all the prosecution witnesses are saying that. And prosecution witnesses are saying that all the village people know that he's of unsound mind. So that cannot be taken lightly.
Lordship, so.
And
a
even it
report
is-
called for my.
How his behavior was
His-
then also.
It is also one,
Mental incident is not a
PW3
one-day affair,
mentioned.
Lordship.
Correct.
PW3 says that so he lives in jungle here and there. Hardly he comes to his house. So PW3 is stated that way, and it shows that it is the abnormal condition of a person like that.
But then at that relevant point of time, we don't know.
Yes, my lord. That is
The report will be there, Lordship, that it will be clear that he was, after he was caught, arrested, Lordship, his behavior will be different, Lordship. Not a similar like that.
He's still.
in examination, under section 313 also, he also.
It is only to see whether his body is healthy or not, that's all. If they don't have mental state, so they don't. No, we're just discussing, you see, whenever this UTPs or whoever are sent to a doctor, the only purpose is to see whether they're mentally
Yes,
fit or not,
yes.
physically fit, I mean. Mental aspect, they don't really look unless it is very apparent, and that happens only after talking to them. Otherwise, by a person's walk, you cannot say whether he's mentally ill or not.
Yes, my lord.
Movies also we see, Lordship, a person convict who are suffering from mental illness is to carry this, the particular
Bucket.
bucket and all, which was. By law.
His behavior is
Please,
different.
So it may be, from
Movies-
behavior.
Movies are different.
No, but
In real life, you don't see couples running around trees singing to each other.
No,
You
no.
don't.
That
No,
is
his
true.
behavior will depend upon, it may not behave normally.
Normal
in the
people,
jail.
Lordship.
The kind of treatment is, in fact, in this jail asylum also,
Yes, yes.
in jail there's kind of.
Lordship,
They
that will be clear,
ask
Lordship.
them to carry a bucket with full of
Lordship,
and then.
something different.
Whether he can remember, recognize why I'm carrying this bucket, but why this again? And
That-
kind of treatment.
Only that behavior will reflect, Lordship, that as if he is normal, Lordship, then his behavior will totally different, and if he is insane, Lordship, then in mental illness, he will not react like. so.
Supposing one person is 99.5, then what? It depends upon different percentages. A person who is,
But
you know,
his medical injuries also will, Lordship may peruse.
It is to be
because it's
ascertained
very
by
bad
the specialized doctor, your lord.
okay. Now let us go back to the case.
case that
Now, as on date, we cannot determine what was his mental condition at that point.
period of time.
I don't know. Can it be determined? I don't know. I don't think, because some of the witnesses have said that sometimes it happens, sometimes it doesn't happen. It was the duty of the court and maybe the council also to take up this plea. Now that has not been done. So that is water under the bridge. The only thing is with regard to whether He is still in that condition now, or he's in normal condition? So in that aspect, what we can do is we can decide the matter as it is on the basis of the material on record with regard to the appeal.
Yes.
And if we come to a finding that the uh, trial court decision need not be interfered with, then that means he'll have to be in custody. In that case, whether he is fit to be in custody in jail or not, for that examination will have to be done.
Because PM report is, medical report is very bad, Lordship. He have, his brain is fractured and scalp is fractured, Lordship. Crushed injury of
No,
the
no, I'm
scalp.
not. Yes, okay. No, that's okay. But now he says that there was no eyewitness.
No eyewitness, yes.
But only 2%.
And
Huh?
In the shed, teen said, Lordship, only two, he and his brother,
They live
And-
together.
they live together. Sometimes he goes out, it is fact. But he lives together, and when the disease, after the disease was lying, he was with a stick.
Okay, he was
That-
still there. Then he ran away.
Then
No.
when people gathered, then he ran to the school and people
Yes,
caught him.
I think that is the
That is
evidence.
the-
is
Yeah,
there.
yes,
is-
my lord, but PW so for the informant, he found a dead body lying, but he also found that murdered weapon was lying nearby the dead body. That
So?
was his statement.
So,
And so far the contradictory
what is
statement,
what is so surprising about that?
yes, my lord. That is
Do you mean
contradicted
that
by
that
Seven and eight.
weapon should not be there?
PW to the informant, he came later on, but PW, 4,
PW 7 and 8, they contended.
Okay, was there any confession?
Lordship.
Confession by
confession,
the
by the
accused confess.
confessed before
Page,
7,
page,
and they are not interested witness. Lordship.
page.
Page number
7 and 8, my
7 and 8. PW 7 and 8, page number,
No,
page.
extrajudicial confession. Okay, say that. Extrajudicial.
Extrajudicial conflict.
Page 7 and 8.
The witnesses said before 7
Page,
and 8.
page,
Page,
page.
I'm
18.
one is in 20, Lordship, page number 20. He is PW 8 and
Is there
the
evidence?
other one is Lordship PW 7. That is page 18.
Okay. Now, what is the value of a extrajudicial confession?
Lordship,
Any citation?
Lordship, I will produce Lordship after some time. I have, but not right now. It's not with me, Lordship.
When
It is in my room, Lordship.
even I've got in my house.
No, it is here, Lordship. Now here, court, Lordship. It is, I can give after 10 minutes, Lordship.
Okay.
Because they are not
So
interested.
your basic case is extrajudicial confession.
uh,
That's all, nothing else.
and circumstantial chain is also completed, Lordship.
Circumstances are there. And what is the intention? What is the motive? Motive for killing. When there is no eyewitness, then motive becomes a very important, plays an important role. So what is the motive?
There was a fight between the
Where does it say that?
his lordship, in
Page.
the extrajudicial confession, Lordship, page number 20, Lordship, where he have stated, Lordship, that as he was earlier assaulted by the deceased, Raju, his brother, so he killed his brother.
So that was
Why
the
did-
motive.
Lordship, that is Lordship, because they were in the drunken state, Lordship. Fully, they have.
Was there, how do you know they were in the drunken state?
That is stated by them, Lordship, that,
Stated by whom?
Lordship,
PW 8
PW8 stated.
in the cross examination.
Who can prove a drunken state of a
Yes,
person?
yes, my
No, just tell me the law. I want to know who can prove a drunken state of a person? How does he say that he's drunk? He acted funny, he started singing some different songs, what?
That is merely the statement of the PW 8 only.
You see, as far as I know, I think whether there's alcohol in your body, I think you might need a blood test. You
It
might
was not done.
need some breath test. I don't know. How does he come to a finding that he's drunk?
Scientists are accusing this habitual transfer. Quantity of offense given has. Lordship in the cross part, Lordship of page number 21, Lordship.
Page 21,
21, down below.
page 21, yes.
Down. From
The-
third
Oh.
line, Lordship, both the accused and the deceased were habitual drunkard. On the date of occurrence, they were heavily drunk and they were found in drunken condition.
One was dead. How can he? There has to be very clear. Either he found him in a drunken condition or he found him dead.
About the
He can't.
accused.
Huh? Or he found him dead drunk or what?
He was not an eyewitness.
How can he say that they were in a drunken condition? That means he was still alive. Now, please see the evidence. It is not the fact that accused did not cause murder of his brother, and the firewood which was shown to me was brought by deceased for cooking meal. Followed him to the market. Okay, that's the wood you bought. You're going to cook eggs with it tonight or what? How does he know all this? Both the accused were drunk, habitual drunkard. On the day that they were heavily drunken.
Right.
Anything else? What
So
about
far-
313? Let us see 313.
313, your lordship.
Page?
Page your lordship will find at page 28.
Okay. And fled away after committing the crime.
Yes, my lord.
Why did you fly? Why did you run away? At page 29. Answer at the bottom. Third last line.
Page
Fourth last
20
line.
Page 29, my lord.
Page 29 of the paper
Uh,
book. 313.
No, I think it is answered in negative. No, I didn't assault my elder brother and fled away after committing the crime.
Oh, okay.
Yeah,
So-
the entire answer is.
Answer.
Yes,
So he did not run away.
he didn't run away.
But then
He was found sitting in the veranda of the school maybe because of the mental condition also. He might be sitting there.
so that means the witnesses who said that he ran away were telling a lie.
No, some witnesses said that he was found sitting in the veranda
He
of
was
the.
found, but he
Yes.
was not found in the, because someone said, I think somewhere, that he fled away.
How it took place,
7 and 8.
I came to the residence of the accused and then I saw Raju Paswan lying. He has already died. I also noticed the accused who was staying near the dead body with a stick in his hand. PW 7.
7 and 8 only. But
PW
so
7.
far the informant version is different. Informant
Informant
found the dead body lying on the ground and that murdered
later
one,
on
that
also.
wooden piece was also lying
Are
there.
are the witnesses interested witnesses?
No, no,
So far,
no one left. All the
Are the witnesses interested witnesses? Do they are they going to gain anything by telling a lie?
there is no
7 and
enemy.
8 only, they have a different theory.
No, my question is not
Yes,
that.
And regarding that extrajudicial confession, your lordship, that one, that the accused confessed before them, 7 and 8. that was contended by them. So far, the PW9 IO is concerned. In this cross-examination, he said that witness Basati Sohan, that is PW7, did not state before me that the accused had confessed his guilt before her. At page 24. That is the IO. So in the cross-examination, 1, 2, 3, 4, 5, 6 line.
Anyways, statements made to police officers are of no value.
Yes, my lord, that is also there. Nepal Sohan and Basati Sohan, they did not tell the police officer that the accused confessed.
PW3 also said, Lordship, that the accused was moving around nearby his house. Moving around.
That is
Naturally, it's natural that someone moves around his house. It'll be very unnatural when he moves around somebody else's house.
After hearing the hue and cry when she came to the place of occurrence, Lordship, with the help of a torchlight,
Yes,
she have
yes.
a PW3, Lordship, page number 12. Page number 12, Lordship.
Page 12.
Lordship.
She was also sleeping under
In my
the
house, my mother, Bakul, 1, 2, 3, 7, 6 line, Lordship. Adjacent to the house of the accused. In my house, my old mother, Bakuli Das, is also there. On the day of the occurrence, my mother heard a sound nearby our house. Then coming out from the house, my mother noticed that the accused is moving around nearby his house. Then my mother saw in the flash of torch, like the dead body of Raju Paswan was lying on the ground with a pool of blood. Then I came to the spot and called other villages. My mother also called the informed. Hitesh Paswan Videpi was also informed. In the meantime, the accused took shelter. And then he took the shelter in the school building, Lordship, after all the people were there.
that is nearby.
Come to page 33. Very rash. He gives a very rational answer. The question number, answer to question number 13.
Yes, my lord.
Please read.
I am mentally retarded person and people took
To
advantage of
my mental state. To falsely implicate in this case, I have not killed my brother.
No.
313 examination 300 section 313.
This,
my
this
lord.
does not seem to be the answer of a mentally
Mentally retarded
unstable person.
very voluntary.
Yet,
Or his lawyer has done a good job. Too good a job. That's all.
Good.
So you have to give me some judgments or not?
so far regarding that FSL, that was not murder weapon, that was not sent to the FSL, my lord. And it was necessary to ascertain as to whether that weapon was used in the murder or not. In
Yes,
killing or
what
not.
do you say? FSL, the weapon was not used, was not sent to the FSL.
But the injury part PM
I
report
have-
also,
But
I can.
regarding this also, Lordship,
that's
I
a
have
that's a very relevant point you're taking.
Lordship recently, I will give some judgment, Lordship. We have
Lordship,
done recently one case, Lordship, that in
There
the
are
case also,
25
Lordship.
in the judgment.
Madam, the only problem is that you should have everything in your.
No, it is in with me only, Lordship. I will supply within the 10 minutes, Lordship. Within 10 minutes.
There are 25, my lord. It's there. There are 25.
Yes, para 25 years.
If the case is in hand examined in the light of the aforesaid settled legal provision, the prosecution has definitely made an attempt to establish the presence of the accused so-and-so is the only eyewitness. His presence also cannot be doubted in view of the fact that he himself got injured in the incident. However, the question does arise as to under what circumstances he has told his sister and brother-in-law that his brother has been killed by the appellant accused when in the substantial statement before the court, he has deposed that he came to know about the death of his brother after being discharged from the hospital and he remained there as an indoor patient for 15 days. Such a statement made in the court also created doubt as to whether he could be the author of the complaint of the region. That in the complaint lodged by him on 26th 1996, he has stated that his brother had died. Similarly, non-production of the FSL report in the court by the prosecution is fatal, as in the absence thereof, it was difficult for the court to reach to the conclusion as to whether the offense has been
Non-production of the FSL report with regard to what?
With regard to the MO1, it is the murder weapon.
Huh?
It is exhibited as a MO1 in this case.
What is MO1?
That is a seizure.
Seizure of what? Shirt, pant, what?
Seizure that was used for murder, my lord.
Where does it say in the judgment? MO1 relates to the piece of wood.
Also regarding
is in terms of
circumstantial
seizure.
evidence and extrajudicial confession, I will give the judgment. As he is not interested person, because the villagers are, or nor they have enmity with the accused lordship. So they will not get any benefit lordship by making him a accused.
You see, a very relevant section in cases of this kind is 106,
Lordship.
where an incident occurs within the secrecy of the four walls of a house.
Oh.
Therein, a duty is cast upon the person living there to explain as to how the deceased ended up dead.
Then,
None of you all were harping on section 106.
that is also in 313 only he have stated that he have denied, nor any story he have placed that how his brother died. But other relevant thing he is answering lordship. If he is mentally ill person lordship, he could have answered none. He will have keep mum lordship. But in that regards lordship, he have answered. But he have not. He have only denied the offense, but he have not stated how his brother died, or his brother have enmity with somebody else, or he was not present in the house. Nor nothing here, nothing this sort of thing that they are not. He could have stated, because I was not present. In 313, he have not stated anything. Only simple denial in it.
So you are going to give me the judgment.
That's it. Regarding extrajudicial confession,
How many copies are you going to give us?
Lordship.
Anything else? Yes.
Lordship, this is my humble submission, my lord, on these points, my lord.
Okay.
It was required to be proved beyond reasonable doubt, my lord.
You don't have to be very humble about it. It is a submission. That's all. Anyway, so basically, it's slightly tough.
Yes, my lord.
Okay, right. Heard, Mr.
Deborah, your lordship.
D. Bora, learned counsel for the appellant. You're amicus,
Amicus.
learned amicus curiae. And Mr. and Miss M. Begum, A. Begum, A. Begum, learned additional PP. The present appeal has been filed against the impugned judgment dated 6/4/22, passed by the court of the Sessions Judge Udalguri, Assam, in sessions bracket 1. Bracket 1 or I? What is this?
Roman
I, Roman. Bracket close, case number 71 of 2019, comma, by which the appellant has been convicted under section 302 IPC for murdering his brother and has been sentenced to undergo rigorous imprisonment for life with a fine of rupees 5,000, in default, to undergo simple imprisonment for another 6 months. Full stop. Next para. The prosecution case in brief is that an FIR dated 3/4/2019 was submitted before the officer in charge Khoirabari PS by PW number
PW2, my lord.
PW2, who was a villager living in the village of the appellant. The FIR stated that at around 10 p.m. on 2/4/2019, the appellant had hit his elder brother Raju Pasawan on his head with a piece of wood while he was sleeping. The elder brother Raju Pasawan died. The FIR also states that there was no other person in their family except the two brothers who were both unmarried. Pursuant to the FIR dated 3/4/2019, Udalguri PS, no, PS, Khoirabari PS case number 10 of, no, what is the PS case number?
PS case number, my lord. 10/19.
Khoirabari PS case number 10 of 2019 under section 302 IPC was registered. Next para. The case IO thereafter went to the place of occurrence.
Yes.
And seized a piece of wood which had been used by the appellant for hitting his brother. Inquest of the dead body was made and the body was sent for post-mortem examination. After examining witnesses and the appellant, the case IO submitted a charge sheet having found a prima facie case under section 302 IPC against the appellant. Next para. The learned trial court thereafter framed charge under section 302 IPC against the appellant, to which the appellant pleaded not guilty and claimed to be tried. 10 prosecution witnesses were examined by the learned trial court during the trial proceeding. Thereafter, the appellant was examined under section 313 CRPC and the learned trial court thereafter came to a finding that the appellant had committed the murder of his brother, the deceased. The appellant was accordingly convicted under section 302 IPC and sentenced as stated in the foregoing paragraphs. Next para. The learned counsel for the learned amicus curiae submits that the entire case of the prosecution rests on circumstantial evidence and the extrajudicial confession made by the appellant to the to PW number 7 and 8. It's Pusam. He submits that the circumstantial evidence do not form a complete link or a complete link slash chain to enable the to allow the learned trial court to come to a finding that the appellant was the only possible suspect who could have committed the crime against the appellant, against the deceased. Full stop. He also submits that the evidence of the prosecution witnesses all point to the fact that the appellant was mentally ill and in view of section 84 of the CRPC,
IPC.
of the section 84 IPC, comma, the act done by the appellant. No, the appellant could not have been convicted of an act done while he was not, while he was mentally ill. Full stop. He also submits. What about the extrajudicial confession? What have you got to say?
In that regard, my lord. There, but they didn't say it to the IO.
Before that, you write, in this regard, he has relied upon the judgment of the Supreme Court in the case of Rupesh Mangal,
Yes.
bracket Thapa, versus State of Sikkim, 2023, 9 SCC 739.
Yes.
Okay, with regard to that, yes, Mr. Yeah, Michael, with regard to whether the with regard to the value of the extrajudicial confession, you have got no submissions to make. Only your only ground is that it was not stated to the case IO. Is it?
Yes, my lord, they didn't, they never told it to the IO.
They did not. They did not mention it to the
Yes,
case
yes,
IO.
my.
So what is wrong with that?
So far that is there.
Huh? That's all. Nothing. What is the consequence of not telling it to the IO? Look, you have got to give me. You see, by telling me the facts, that does not help your case unless you are able to show that by not telling the IO, the consequential effect of that would be this or that. Something, you see, you cannot ask me to fill in your blanks.
Yeah, yes.
Okay, then what else?
Yes, my
What is the other submission?
Regarding that murder weapon, that was not sent to
Okay,
the.
right. Next,
in the-
the learned amicus curiae submit that the murder weapon, the alleged murder weapon,
Yes.
that is the wood that had been used by the appellant to kill his brother, had not been sent to the FSL for examination, comma, to prove that the weapon was to prove that the wood was the murder weapon,
That was used in.
comma, even though the same had been seized by the police. Correct?
Yes, my.
In this regard, he has relied upon the judgment of the Supreme Court in the case of
Yes, Shankar.
A. Shankar versus State of Karnataka, 2011,
Six.
6 SCC 279.
Yes.
Anything else?
My lord, that is my submission.
That's all.
Yes, my lord.
Okay, one more. And the learned amicus also submits that.
53 paragraph.
Just a minute, madam. We are still continuing with him. He has not finished. Submits that though the appellant had allegedly given extrajudicial confession to PW 7 and 8, the same cannot be acted upon in view of the fact that it was not the IO was not informed of the same. Anything else? He accordingly submits that as there is lacuna in the finding of the learned trial court in convicting the appellant, the impugned judgment and sentence should be set aside. Yes. Ms. A. Deka, the learned additional PP submits. Ah, A. Begum, sorry. That's why you.
Repetition of only the cup, we accuse like that.
My lord, actually, I skipped one. Section 328, that was not adhered to by the trial court.
No, that you had no clue. Only it
Even
came out
after
through.
knowing that,
You had no clue. It only came out now. That was not a submission. That is not a case also.
so because all the prosecution witnesses, they repeatedly they told that he was the person of unsound mind that time. So that it came to the knowledge of the judge also,
Okay.
To the court
Okay,
also.
you're right.
and he would have
You're right. He also submits that as the prosecution witnesses had consistently given their testimony to the effect that the appellant was mentally ill,
Yes,
it was the duty of the learned trial court to have the appellant examined by a surgeon,
civil surgeon.
say
or a
civil
medical
surgeon,
officer.
in terms of section 328
Yes, my lord. CRPC.
CRPC. So, what do you want now?
So that lacuna was there.
Not done. You did not bring it up also before the trial court.
But when it comes to the notice of the court, knowledge of the court can also, court has.
That is
also
only
taken
evidence.
initiative to
There is
ascertain so that justice is not miscarried.
okay. He submits that the non-compliance with the provisions of section 328 CRPC has vitiated the trial, and as such, no conviction could have been based on the actions of a person who was mentally ill. I have heard. Okay, sir. Okay, madam, we'll take a matter 2. So
I have given,
not only that, you just tell me your points.
Lordship, 51 to 52.
No.
Oh.
Your submissions,
Oh, Lordship,
your point
yes.
form,
Lordship.
how you're countering his points, one in point form, your citations,
Yes.
you take it up at 2.
Okay.
Actually, I've got another third matter too, but we cannot have 2. We'll carry on at 2. You tell them. That's 2, huh?
Yes.
She's ready with 2 copies of the test.
I have to
You be ready with the 2 copies,
supply.
2, and then with the paragraph that you're going to rely on, and also the points which you want
for.
to address, no?
Lordship.
Oh, point form, that's all.
Lordship.
We will fill in the blank. You just give me the point.
Not two judgments, of course, here, my lord, it was relied upon, my lord, the victim's statement was relied on, but here there were some medical evidences, my lord. And one judgment, my lord, of our honorable High Court, my lord, which of course I could not get a copy immediately.
There is a judgment of regarding state of Sikkim.
My lord.
Supreme Court judgment where doctor's evidence is prosecutor's evidence
Is sufficient. In one judgment of our High Court, my lord, it was set aside, my lord, on the ground of there being no medical evidence, but there were other infirmities in the statement of the victim, my lord. That is, my lord, 2018 3 GLR 291. Couldn't get a copy, my lord, the 2018 3 GLR 291.
Okay.
Ranjit Hazarika.
2018
18 3 GLR 291.
para
My lord, para, my lord, 12, my lord, 12. Then was 15, my lord. There was no doctor's evidence, my lord. Here the conviction was set aside, my lord. It is criminal appeal 55 of 2015. And my lord, there are two judgments. One is Ganeshan, my lord, versus state, my lord. That is 2000. This I have copied, my lord.
2000
2020 10 SCC 573.
2020 10
10
SCC
SCC 573.
para
My lord, para, my lord. My lord, 10, my lord. 10 11, my lord. This, of course, my lord, minor contradiction should not be, my lord, taken into, my lord. Should not be, my lord, allowed to throw the judgments away, my lord, the statements away.
minor inconsistencies.
My lord, should not be allowed to throw the
How has that got any effect?
My lord, no, here, my lord, yes, my lord, that's true, my lord. But this also says, my lord, that without, my lord, corroboration, my lord, it can be accepted, my lord. This goes against me, my lord. Then, my lord, Raghubir Singh also, my lord, similar. But here, my lord, there were some medical evidences, my lord, to corroborate the incidents, my lord. There is.
Out here, the problem is no examination done on the hymen itself.
Yeah.
It's not that we are shying away from the work, but there's no point hearing you and not being able to complete. I cannot keep it part-head.
Absolutely.
Because I'll be holding a single again for tomorrow.
Yeah, this. As it may be kept on some other date then. But sometime next week, because Mr. I'll just bring it to the notice of the Honorable Court. So DK Bhattacharya is appearing in the matter. He has filed a leave of absence till 24th of this month, till Tuesday. So any day post that.
Yeah, no point. Right. Mr. DK Bhattacharya is for who? Is for
the appellant.
appellant.
I am Mr. A. Gautam appearing on his behalf.
Right. Adjournment prayer has been made on behalf of Mr. DK Bhattacharya.
That's very respectfully, that may not be reflected because the IA for bail was disposed of on the last date by your lordship's coordinate bench, and there was a condition which was imposed that we cannot seek an adjournment.
Oh, okay.
A condition for bail was imposed. But in all honesty and very frankly, I'll tell the honorable court that. So joint prayer will be recorded.
Okay, just right. On the prayer, the parties list the matter on
Any date, post 24th. It's 26th if possible, because he'll be back.
26th.
It's a Thursday. Yes. Grateful. Okay.
Finish. Oh, finish.
Supply problem.
Oh, supply. Yeah.
Settlement arrived at. So end of the matter, give me a settlement.
No, there is a medicine report.
Huh?
The medicine report is there.
The medical report is there. Where is
What's
the
it called?
medical report?
Only one. Only one thing, lots of in the medicine report. there is a mention of payment of 13,500. We tried our best from the side of the respondent also, but
Right. I can, right. No, reason could go in, so this is like. Yeah, reason. It's to put full in, it's told the. So yes, maybe. Maybe. But where were we? I don't remember. That's the problem. That is the problem is I wasn't I didn't even I wasn't sure whether this case would come up even till tomorrow because I was suddenly shifted to the division bench. Yes, yes. On Tuesday from Tuesday. Yeah, yeah. So after exhausting day, it is starting. I've got 3 CAVs to dispose of. If I had known that this case would be taken up, I would have dictated those 3 judgments in court. Yeah. Anyway, we leave it to your lordship. If your lordships. Because see,
We
right
have no
now,
problem, you can be next Tuesday also, there is no problem.
I think better because I've got those are in my
Yeah.
thing.
and
I thought
then
I'll dictate those.
In any case, it will not be over, therefore one can start at, on Tuesday next. No? No, what? Thursday? কেতিয়া কোৱা তোমাৰ সুবিধা কোৱা date. Whatever date suits your lordship, we have no problem.
No, I've got no problem as such. Only thing is that today, because of those,
Yes.
if when mind is still fresh,
There,
I can dictate. Otherwise,
it
And
should not weigh on your mind about some other matter.
yes, because you see, otherwise
Yeah.
I'll have to read the entire file again.
No,
That is the problem.
please don't take that trouble. We can have it next week or something. In any case, it will not be over today. Wow, it will be after vacation. Wow,
But can it be on 1st of October, just before the vacation? The last week,
We can try.
I have to keep a.
Mongolwar.
I have no problem.
We can try first.
First of all, no?
1st October at 2 o'clock.
Yes,
That is okay.
that will be better.
Correct. On the prayer, the party close the matter on 1st at 2 o'clock. First October I'll be there, but second October I'll not be. Second, I'm not going to be here on 2nd October.
Let us be confined.
Second is a holiday.
But first,
You sure you won't complete on 2nd? Then it depends upon the.
let us see, you want it on second or what? First, let us have it on first. No? First one, Bondo.
So everything will depend upon Mr. K. Goswami and Mr. Das.
Yes.
How long they will take?
We are coming to a close, my lord.
I will not take days, as my learned friend has taken.
How many hours will you
Be
take?
fair to me,
I-
he have not given me a full day any day.
I take at least 1 hour.
1 hour,
That's it.
half an hour, 1.5 hours. Mr. Goswami will take, I think,
I am happy
Sometime.
with what I hear, because I will not take a risk of projecting time.
okay, right.
itself.
So they did that. Okay, on first.
First, 2 o'clock. my lord.
If you can complete, it'll be good because then
Yes.
during the holidays we can do.
Yes,
something.
Yes.
If you don't complete, of course, then we're going to have a tough time.
Yeah,
I've got to go
that is
through it
one
and,
good thing, your lordship.
and that what the notes I had put in that I cannot find. I've got to search for it that's somewhere.
No, it should be there somewhere.
No, that typed one is there,
Ah.
but the handwritten notes I have to look for it. So I was suddenly looking
Good
for
that
it.
your lordship dictated the order
Little bit,
when
yeah.
it was fresh.
That is what.
Ah.
And unfortunately, today we have put 3 CAVs, criminal matters. So
And by that time, my lord,
yes, now I can at least dictate.
Yes, yes.
very good that your lordship dictates, otherwise in a longish matter, it
Yeah.
becomes difficult to
Right.
remember. That is what late H.R. Khanna used to do.
These are different caliber. We thought.
No, in
Yeah.
long matters, that's what he told me, that I always dictate and
Ah,
there is hearing.
helps.
Ah,
Very good, justice there.
Yes, yes. Yes, yes. Oh, yes. We have our Justice Sangma,
Ah,
who had the courage, my lord, to give a stay of the presidential warrant for appointing a judge in this court.
This,
Your lordship will know that case.
Yes, I know.
Mizoram.
From Mizoram state, yes.
Yes. It is one of the most important interim orders I have seen,
correct.
and it was vindicated by the Supreme Court. That order had to go.
Anyway,
He was absolutely right in granting that stay.
okay then.
Okay, all lordship.